Hello, everyone. We will start in a moment. We will just let a few more people in.
Hello everyone, welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we'll share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So without further ado, I'd like to hand over to our speakers to get us started.
Thank you, Muna. My name is Yocheved Novogroder. I'm a partner in our known Tadmor Levy's privacy practice and commercial transaction practice. And I'll be presenting today with my colleagues Netanella Treisman and Miriam Friedman, who are also partners in our privacy practice and commercial transactions practice. Michael, if you can go to the next slide, please. Just a word about our firm. We are a full-service law firm located in Israel. We represent many international clients, both in the area of privacy as well as other areas. And we're delighted to be with you today. We're here today to talk about Amendment 13 to the Israeli privacy law. And let's put Amendment 13 in context. Israel was a leader in the area of privacy. We've had a privacy law since 1981. And as a result of the very early adoption of the law has over time become not suited to modern technology and not necessarily in sync with international data protection mechanisms. And Amendment 13 is an attempt to remedy both of those deficiencies. It is both intended to make the law more relevant to what's happening in the real world, as well as to harmonize Israeli law with the data protection regulatory structures of other jurisdictions. Israeli privacy law, including Amendment 13, has been inspired by GDPR, but there are some fundamental differences, and we'll cover some of them in the course of our discussion today. Israeli privacy law deals with both databases as well as substantive privacy rights. And then Amendment 13 addresses primarily the area of databases. So we're in the world of collections of personal data that can be manipulated electronically. We're not necessarily going to be addressing the Israeli regime as it relates to fundamental privacy rights, right to use your name and likeness for economic purposes or unlawful eavesdropping. We're really talking about databases. However, the sanctions that are introduced by Amendment 13 do address fundamental privacy rights, and Netanella will tell us a little bit about that as we proceed. So the changes introduced by Amendment 13 are quite wide-reaching. If we can go back to the prior slide, thank you. Are quite wide-reaching, but if I had to identify one specific element of Amendment 13 that has the greatest impact, it would be sanctions. Sanctions. Historically, the penalties that could be assessed by the Israeli regulator for violations of Israeli privacy law were relatively low in comparison to the remedies that were available in other jurisdictions. And one element that we saw in our practice quite often is in particular with respect to international companies who were operating in Israel. Very often they would take a risk-based approach and say, okay, the penalties for Israel are quite low, and therefore we're not necessarily going to be considering Israeli privacy law as we create our privacy compliance program. All that changes with Amendment 13. The penalties that can be assessed by the regulator are very, very high. It can lead to millions of shekels quite easily. And in particular, one of the major changes that were introduced in the context of Amendment 13, and we'll speak a little bit more about that later, is that the regulator has the ability to assess penalties for data security violations. Israel has a data security regime that's quite different from that exists in Europe under the GDPR. We have extremely detailed, extremely granular data security regulations. And prior to Amendment 13, the regulator did not have the ability to assess penalties specifically for violations of those regulations. Now the regulator does. So we all have 8 months to get it into shape in terms of compliance with the new law. And there are going to be affirmative steps that they're going to have to be taken by any entity that is subject to Israeli law in order to be compliant with the law as it's been amended. We have quite a number of international participants today. So just a word in terms of international application of Israeli privacy laws. Unlike the GDPR, Israeli law does not specifically address international application of the law. So there's an open question. Is a non-Israeli actor that's collecting and processing information of Israelis subject to Israeli privacy law and to Amendment 13? So I'll start. Which means that in order to export data from a database in Israel to a recipient outside of Israel, you need to establish legal basis for the transfer. And one of the legal basis for export of data from a database in Israel to an international recipient is an opt-in by the international data recipient to abide by Israeli privacy laws. So obviously, if you're a non-Israeli entity and you're receiving data from an entity in Israel, from a database in Israel, and you've used that opt-in as grounds to establish legal basis for the export, then you will be subject to Israeli privacy law, as well as Amendment 13. But what if you're not exporting data? What if you're collecting data directly from data subjects? Let's say you're an international retailer and you're selling products to consumers that are located in Israel. Or let's say you're offering a digital health solution and you have an ongoing flow of health data from patients in Israel to your operations outside of Israel. Are you subject to Israeli law? And there again, the law itself does not address the extent to which entities that are physically located outside of Israel would be subject to Israeli law, including Amendment 13. General principles of territorial application of law will apply, including nexus to activities in Israel, whether activities are taking place physically in Israel and the like. The Israeli Data Protection Authority has taken the position that any international actor not acting in Israel that is engaging in activities that, number one, involve a collection of a significant amount of personal data from Israelis, and number two, the collection and processing of that data would have a significant impact on the privacy rights of Israeli data subjects, would be subject to Israeli law. Obviously, that analysis is a case-by-case analysis. It's very fact-dependent. Miriam will talk about other aspects of international aspects of Israeli privacy law in just a moment, but first let's talk about some changes that were made to the basic definitions under Israeli law by virtue of Amendment 13. So there are a few key changes that were made in terms of the basic definitions. The first is with respect to the definition of personal data, which is obviously the fundamental definition under the law. The definition of personal data under Israeli law prior to Amendment 13 is a closed list of data. That closed list, again, was implemented quite some time ago, and it's been expansively interpreted by Israeli courts, including the Israeli Supreme Court, such that it was universally acknowledged that it really did encompass more or less any data relating to an identified or identifiable person. After Amendment 13, we will actually have that principle enumerated in the law. Identifiable is defined as individuals that can be identified using reasonable effort by references to identified personal information. Another new definition that we have in the law is a database controller. And database controller is defined by a person who alone or with others determines the purpose of data processing in the database. Data controller was not defined under the prior law. This is a new definition. The prior law spoke in terms of a database owner, but it was undefined. One notable aspect of the database controller definition, in particular, as it's distinguished from the GDPR definition, is that the criteria that establishes a database controller for purposes of Israeli law is whether or not the entity determines the purpose of processing, not the means of processing. So if you're a data controller that's working with a processor and the processor independently determines the means of processing, that is not sufficient to establish a joint controller relationship under Israeli law. Another key change with respect to the database controller definition is that we now officially have a definition of a co-controller, which did not exist under prior law. Another amended definition of a definition that was included in the prior law is the definition of database holder. And this definition has been expanded. It's defined as an entity that's external to the database controller, processing data on the database controller's behalf. It's more or less the equivalent of the EU data processor, and it's more akin to the definition of the EU processor rather than a third party. As I mentioned, it's a more expansive definition than existed under the prior law, so it means that there is a greater number of entities that are going to fall within that definition and subject to the law's provisions as they relate to database holder. I should just mention that Israeli privacy law in general applies quite directly to both controllers and database holders. Database controllers and processors are responsible for data security, for example, and can be subject to direct liability in terms of regulator action. Another new definition is definition of data of special sensitivity. Formerly under the prior law, we had a definition of sensitive information, and the data of special sensitivity definition is a detailed list. It's more in line with modern privacy laws, and it's relevant to obligations to appoint a data protection officer, as well as database notification requirements. And we'll speak about that in just a moment. One notable aspect of this definition before we advance to the next slide is that this definition, both the personal data definition as well as the data of special sensitivity definitions, relate to economic information, which is a substantial difference from the GDPR. Next slide, please.
Okay, so these regulations were not, these privacy protection regulations, provisions regarding the data transfer to Israel from the European Economic Area were promulgated back in 2023 before Amendment 13, but they're an important regulations to take into consideration when we're thinking about what needs to be done in order to align with Israeli privacy law, and especially also when we're talking about matters of jurisdiction, which Yocheved referenced to before. The context of these privacy protection regulations, which are commonly called the bridge regulations in local parlance, is that the importance of retaining of adequacy status for Israel. Back in 2011, the EU determined that Israel provides sufficient or adequate protection to data, such that flow of the data of the personal data of EEA data subjects to Israel should be done freely and with no additional or no additional restraints. After the enactment of the GDPR back in 2018, the Europeans started to revisit this assessment of Israel as having this adequacy status, together with a very short list of additional countries. And there was a lot of talk in Israel, at the Israeli Privacy Protection Authority and amongst lawyers about whether or not Israel would retain this adequacy status. Again, super important if it again allows the free, pretty much the free flow of data, of personal data from Europe to Israel. There's no need to enter into standard contractual clauses. There's no need to perform transfer impact assessments. I mean, it's super important for the Israeli economy. So when the Europeans started kind of revisiting whether Israel should retain this adequacy status, there was kind of a flurry of activity with Israeli regulators and Israeli Knesset, et cetera, about what to do in order to maintain the status. So several things happened. First of all, there were the data security regulations, which I think Yocheved had referenced shortly before, were promulgated in 2017. Again, as Yocheved said, super specific, very quite actually different from what we see in the GDPR, but still, again, very important. It shows that the Israelis take data security super seriously. There was a government decision about the independence of the Israeli Privacy Protection Authority, which was kind of published everywhere. And another Amendment 13, which we're talking about generally today, and also these the bridge regulations. Basically, it's kind of an anomalous situation. It's a little bit strange. Basically, these bridge regulations afford Israeli and non-Israeli European data subjects with additional rights which they do not have under Israeli law. Basically, you can see the list here. There's the right to be forgotten. Kind of an easier process of requesting data, deletion of data, limiting the retention of unnecessary information. The companies have to have in place ways to, kind of technical measures in order to ensure that unnecessary data, personal data, is not retained. The importance of data accuracy, making sure that the data is correct, up to date, complete, etc. And also additional notice requirements. Basically, when a data subject is being solicited for data, or basically the notice which is going to be published in order to show what is going to be done with these data, they have to address additional aspects of privacy law, mainly the right to be forgotten, which is kind of deletion rights is not blanket allowed or afforded across the board under Israeli privacy law. And by the way, this list is kind of an interesting way of seeing what was not included in Amendment 13. Amendment 13 does not afford these rights to regular Israeli data subjects, but as is written on the slide, as of January 2025, this is kind of interesting. These rights and obligations apply to entire databases that include personal information coming in from the EEA. So if there's kind of Israeli data that is mingled with that data, basically those Israeli data subjects will have these additional rights as well. Additional something that is a little bit strange, and we should take into consideration that these rights are afforded to data which is data from European data subjects, which is not received directly from those data subjects. That's kind of an interesting carve out, which we should take into consideration. Next slide, please. Okay, and unconnected. We're back to Amendment 13. Amendment 13 created a whole new obligation, which did not exist previously under Israeli law. The requirement to appoint a data protection officer. And so first, there are criteria under the amendment, which entity needs to appoint a DPO. And a lot of these criteria will sound very similar to people who are familiar with the GDPR and the GDPR requirements to appoint DPOs as well. First of all, there are public entities. That would be government offices, municipalities, etc. Data brokers, companies that sell data, and other entities, and this is, I guess, the most important category for most of us, is other entities, other regular companies that engage in regular and systematic monitoring of individuals, or such entities, the main activities of which involve processing a particularly sensitive information on a significant scale. The criteria are vague. There are some examples provided in the law: banks, insurers, hospitals, HMOs, but otherwise we're not really sure to what entities, to what regular companies these obligations would apply. We assume that at least in the beginning, there's going to be a lot of referencing to kind of statements and positions by by the Europeans, the WP29 opinion paper, the EDPB guidance, any guidance received from Europe, such as, and I like to bring this as an example, it says it's obvious that a hospital needs to appoint a DPO. It is obvious that a doctor does not have to appoint a kind of a single doctor with a single practice, with this kind of small practice does not have to appoint a DPO. But kind of in the whole range in between, it's a little bit unclear. We're in a bit vague, and many lawyers, many of us have been asking the Privacy Protection Authority to provide further guidance. They're very reticent. They keep saying, come to us if you have questions. This requirement to appoint a data protection officer is separate from a requirement to appoint a CISO, someone who's in charge of data security. That's a whole different role in a company, and it cannot be the same person who's both a DPO and both a CISO. The requirement to appoint a CISO has already existed in the pre-amendment law. The amendment kind of broadens the obligation, but we do note that it wouldn't be that many companies. You'd have to have 5 registrable data or notifiable databases, either that you hold on behalf of other entities or that you control yourself. Next slide, please. Thank you. So basically, the DPO has to have in-depth knowledge of privacy law. That's where the main emphasis of the law, and also has to have additional kind of technical knowledge and understand what the company's products are and have that kind of technical understanding, but perhaps not as much as the in-depth knowledge of privacy law. The DPO is not a person who's in charge of actually kind of executing, performing, or he's more he or she is more the person kind of supervisory, and advisory roles, kind of bringing it all together. Having one kind of person to look to ask these kind of questions, kind of serving as a knowledge hub. Basically the organization's professional authority on privacy matters. His or her job is to advise management and also other employees in compliance with the law, again, privacy law, developing and overseeing implementation of a training program for the employees. Employees should have this awareness of what privacy law requires, data subject rights, etc. The DPO should also be involved in monitoring compliance with privacy law, and he or she should create a program for continuous monitoring of such compliance, and ensuring that it's executed. Also reporting findings to management and recommending corrective actions. Next slide. So also there's kind of something that's a little bit more detailed, more specific to Israeli law. The DPO is required to confirm the existence of an information security procedure and a database specification document. These are documents which are specific, very high, Israeli specific documents that are required under the data security regulations. So this is the job of the DPO to make sure that they're in place and ensure that they're prepared, and also that they're approved by management in accordance with the regulatory requirements. Handling data subject requests is super important. Israeli law, as we said before, does not grant the Israeli data subject as many rights as the European data subject, but we do have the, Israeli data subjects are allowed to request inspection of their data, correction of their data, and sometimes to also ask the deletion of their data. The DPO, and because the DPO's role is to handle data subject requests, basically his or her details and contact information need to be published somewhere where, again, data subjects have access to this data. Also liaison with the Israeli Privacy Protection Authority, also kind of similar to what we see under the GDPR. Other elements that are referenced in the law, basically the DPO is not allowed to be in a position of conflict of interest. And it actually says specifically that the DPO can be a service provider. We don't have that language with respect to CISOs, but our understanding is that CISOs also are very commonly service providers.
So moving on to the next notable change in Amendment 13 is there's been a fundamental change with respect to the obligation to register databases in Israel. This is a quite unique aspect of Israeli data protection law. It's absent from many the data protection frameworks of many other countries. Prior to Amendment 13, there was quite a broad obligation to register databases, and it involves filing a database registration form with the Data Protection Authority here in Israel and filing an annual update with respect to that form. The database registration obligation was universally acknowledged as not meeting its purpose. There are simply too many databases out there. It did not enable the database authorities to exercise any sort of supervisory role. And consequently, under Amendment 13, the database registration requirement has been abolished for the vast majority of databases. So, for example, prior to Amendment 13, every company was obligated to register its employee database because it included economic information, which was deemed sensitive under the prior law. That's no longer the case. Database registration is now required for a very small subset of databases, and it's defined with reference to the intended use of the data and the number of data subjects. So database registration is now only required for data brokers collecting information and transferring it to others as a business, where they have data of more than 10,000 data subjects. The timing for the database registration is 60 days prior to the use of the database, which is a quite outdated mechanism because obviously databases can be created with virtually no effort. In the past, this obligation to register a database 60 days before the database is used was not necessarily enforced by the database authorities, and it'll be interesting to see what happens under following the implementation of Amendment 13. In light of the substantial reduction in the database registration requirements, we have a new database notification requirements, and that's a requirement with respect to a subset of databases that previously required registration and now no longer do. So the database notification obligation applies to databases having data of special sensitivity with more than 100,000 data subjects. It is not limited to data brokers. It's any database that includes data of special sensitivity with more than 100,000 data subjects. The timing for making this notification is 30 days from meeting the threshold. Both the database registration obligation as well as the database notification obligation are the responsibility of the data controller. And bear in mind that even though we will have abolished come August, the database registration obligation for virtually all databases, there still are other obligations that apply with respect to databases. So internal documentation needs to be maintained, and it's important that companies continue to maintain that documentation. In the event of audit, they'll be able to demonstrate compliance with the data protection obligations in Israel. Next slide, please. Next slide, please. Okay, now let's talk about the requirements of processing for processing in Israel, which are quite different than the requirements for processing under other jurisdictions. So unlike the GDPR, Israeli law does not prescribe legal basis for processing. Israeli privacy law is a consent-based regime. So what it means is that in order to demonstrate that you have a valid grounds for processing personal information under Israeli law, you need to demonstrate that the data subject has consented. This existed prior to Amendment 13. It will continue to exist subsequent to Amendment 13. I should mention that Amendment 13 is not the only amendment that's going to be implemented. There is Amendment 14 that's currently being worked on at the Ministry of Justice, and that will include legal basis for processing, but at the moment and come August, that will still not be in place. So how do you obtain data subject consent in order to legitimize the processing of information under Israeli law? Very often, the vehicle for obtaining that consent is the privacy notice. And that means that the significance of the privacy notice under Israeli law has a special significance. It's quite important. And there are two specific changes that are implemented by Amendment 13 with respect to the privacy notice. First of all, there are new disclosure obligations for the privacy notice. The privacy notice must disclose the details of the controller, data subjects, access, and correction rights, meaning disclose the fact that these rights are held by data subjects in Israel. Previously, that was not the case. And the database notice also must identify what are the consequences if consent is not granted. Notably, Amendment 13 does establish specific penalties for failure to provide adequate notice. I should just make a note, Netanella will tell us a little bit more about penalties that are available under the law, but there are specific penalties. If we can just go back to the prior slide for a moment. There are specific penalties that are applicable to failure to provide adequate notice. For example, these are based on a per data subject basis. And if you're collecting data having special sensitivity, it's 100 shekel per data subject, which means if you have, for example, 20,000 data subjects, you can very quickly reach the millions of shekel in terms of penalties for failure to provide adequate notice. So all companies are going to have to revisit their privacy notices and make sure they are up to date and do comply with the changes introduced by Amendment 13. One additional aspect of Israeli, we'll go back to the prior slide for just a moment, with respect to processing data in databases is the purpose limitation. There's a principle that data may only be processed for the purposes for which it was provided by the subject, by the data subject. That is still in effect. It is not changed by Amendment 13, but two new express provisions were added by Amendment 13. The first is an express prohibition on processing data without the data controller's authorization. And the second is an express prohibition on a controller's processing of data that has been collected in violation of applicable law. Next slide, please. Senator Tonella, over to you in terms of enforcement penalties.
Thank you, Elizabeth. So yeah, enforcement. The amendment grants the Privacy Protection Authority, the PPA, additional inspection, investigation, and enforcement powers. As part of the PPA's obligation to supervise, the PPA can send questionnaires to relevant parties. It can also request documents or information, including system data such as logs and even access certain locations, which of course does not include private homes. When there's a suspected violation of privacy, the PPA can request a search warrant. The amendment also presents new criminal offenses, which include unauthorized processing of personal data, interrupting inspection procedures, or intentionally providing misleading information to data subject when the data subject requests his or her personal data. The PPA may investigate these criminal offenses, and as part of can interrogate or detain people, request court orders, seize materials, and even has more rights with respect to these criminal offenses. The amendment grants controllers the right to request pre-rulings, which the PPA can publish, either anonymized or not. So it's going to be interesting to see if companies will actually use that right. The PPA also has various administrative enforcement measures. For example, it can notify an organization of a breach that should be terminated. It can issue an administrative warning, and it can apply to an administrative court to request an order when specific violations have been committed, or the PPA has reasonable suspicion that it will be committed, such as violations that relate to the use of the data for a different purpose than for which it was collected, or an unlawful purpose. And it also includes violations of data security. The amendment also allows the PPA to impose increased penalties, like Yocheved just mentioned. And these will actually depend on the type of violation, the number of data subjects. That's what Yocheved also mentioned previously, repeated or ongoing violations. So that could easily reach hundreds of thousands of shekels, or maybe even millions of shekels. The head of the PPA may actually reduce the penalties subject to certain considerations, and that can be up to a specific percentage of the penalty. The fines are generally capped at 5% of the business's annual turnover, and there are actually much lower maximum fines for small and very small businesses, which is interesting because we don't see that, for example, under GDPR, where small businesses are defined as businesses with an annual transaction volume of the previous year between roughly $1.1 million and $2.7 million. And very small businesses are businesses with transaction volumes of up to a little over $1.1 million. The amendment also grants the data subjects the right to compensation without proof of damage for privacy infringements, such as processing personal data without registering a database, where the database needs to be registered. And as Yocheved mentioned, that will be required in less instances than now. Also for failure to provide notice, failure to grant data subject rights, such as the right to review or correct personal data. For some of these, the controller will first have a right to correct before damages are awarded. And the compensation here will be limited to 10,000 shekel, which is roughly $2,700, a little over $2,700 for each infringement. We'll move now to director liability. Miriam.
Okay, so this again is a subject which is, well, first of all, very important, but it was not addressed in Amendment 13. This director liability is addressed in a directive that was published by the Privacy Protection Authority. It was published on September 3rd, 2024, and it was updated on October 9th, 2024. And unlike the amendment, which is going to come into effect next summer, companies in Israel were given a whole year in order to get their act together and figure out how they're complying. The directive basically started applying, came into effect on September and October, and it's super important and something which worries a lot of clients, worries a lot of companies. First of all, we have the criteria for applicability. Now, this is going to sound very familiar to what I described when I was talking about the obligation to appoint a DPO. And yes, indeed, it is super similar. Basically, companies in which processing of personal data is at the core of their activities, or if their activities create increased risk to data subjects' privacy rights, and this increased risk is determined by various characteristics of the company, the types of data processed, relating to the especially sensitive data that Yocheved talked about, also reference to an appendix to the data security regulations, which also discusses especially sensitive data. So types of data processed, the number of data subjects whose data is processed, and the number of persons with access rights to this data. Additionally, the directive addresses whether, for example, the data of children is processed. An earlier version of the directive also applied this directive to any publicly traded companies. My assumption is that there was quite an uproar on that matter by the various publicly traded companies in Israel. So that was taken away, and now basically the analysis is performed using the criteria that are listed here. Basically, this directive comes from the world of what is appropriate corporate governance. One thing that is emphasized both by the Privacy Authority and also by the directive itself is that this is their way of helping companies. This is not their way of being punitive or being unduly burdensome. I don't know whether all companies would agree. Basically, this directive is based on many derivative suits, many of them from the US, some of them from Israel. What happens when a company is in a breach of law? What happens when, I don't know, there's, for example, data breach or some kind of huge fine imposed upon a company? What responsibility, if any, can be attributed to the directors? Basically, directors, we know, have a duty of care. They also they are required to create policies, and they're required to, they have this obligation of oversight. What is an appropriate applying of business judgment rule or the business judgment, right? What are the activities of a reasonable board of directors? So all of these all of this kind of case law and what for the Israeli companies law states and everything sort of brought to the Privacy Authority to say that they're going to be imposing certain obligations upon the directors. They talk about, for example, the important US case law is Caremark, which is a very old case from 1996, Marriott, which is much more recent. Basically, sometimes we're going to say the directors are responsible if they had utter failure of oversight, but sometimes there's heightened responsibility, and they have to create these various programs and have reports made to them in cases which are considered mission critical matters. And basically, the Privacy Authority is saying that matters related to data, especially when there is a lot of data that is being processed, are going to be deemed to be mission critical, and basically the board has to take a more active role in ensuring compliance with the law. There isn't, by the way, the directive does allow the board to delegate roles, but such delegation has to be well documented. The reasoning has to be documented, and also they have to continue the oversight. It's not kind of a delegation and then they forget about it. Next slide, please. So the role of the board, this is, first of all, a non-comprehensive list. These are just examples that the Privacy Authority wants the directors to sort of be in charge of. There are two documents, the database specification document and the information security procedure, which I referenced when I was talking about the DPO. We're seeing them here again. These are these have to be finalized and discussed, they have to be discussed before being finalized by the board. Risk assessment and penetration test results. Basically, the board should be discussing the findings and including corrective actions. Security incident reviews, if the company has any kind of security breach, and they have to, basically, the board is required to conduct quarterly or annual reviews of the incidents. Also, audit results, basically, they're mandatory biennial compliance audits. So basically, the board is supposed to review the results of the same. So,
this is a topic we discussed earlier. We can go on to the next slide. Thank you. We can continue as well.
yeah, yes,
So-
yes. Okay, thank you. So just as a summary to our discussion today, we have made a list of what should companies do, what should lawyers be aware of, what should companies be aware of when they're thinking about compliance with the new data privacy regime in Israel. Take into consideration both Amendment 13 and also the other pieces of legislation and directives that we discussed during this talk. One thing is we propose that companies should deregister their databases. As Yocheved said, the requirements to register databases has been very, very, very narrowed. If most private companies, if at all, would only have to notify the privacy authority about certain databases with quite a lot of with data about quite many data subjects. Basically, other databases that were registered prior to the amendment should be deregistered. There's going to be some kind of procedure to do so. We're not 100% sure. Hopefully, it will be an easy procedure or just some kind of quick email or whatever to the privacy authority. Note the implications of wider data definitions. At the beginning of the talk, Yocheved talked about how the various definitions have been updated, have been broadened, have become more modern. They're more aligned with definitions under the GDPR. We assume that these wider data definitions might not always be very different from for example, what we've been advising our clients, because as Yocheved said, Israeli case law broadened the list, broadened the very narrow list that was included in the older version of the law, but still we advise that companies should note the implications of the wider data definitions to ensure, perhaps do this by doing some kind of data mapping exercise, ensuring that they don't have to approach the data that they process in a different way, and connected to this implications of noting these implications of wider data definitions, broadening the notice, privacy notices, any forms that need to be filled out by data subjects when they're providing their data. We should ensure that they have the new language and the new requirements, their new disclosure obligations, as Yocheved said, for example, what are the consequences of not providing certain data to the company, being very specific about data subject rights, inspection and correction, all these things should be addressed. Draft a policy for response to data subject requests. I'm sure many people here remember that after the GDPR was enacted, there was quite a spate of data subject requests that were sent by various offices around the world to companies on behalf of very, very many clients. The assumption is that in Israel that's going to happen as well. Because of the broader enforcement rights, because there's more of an emphasis on these data subject rights, etc., we're assuming there's going to be many more applications requesting all sorts of data subject rights. And as we've noted before in this webinar, do note that under Israeli law, Israeli data subjects do not have a broad right to be forgotten. It's much narrower than the right under the GDPR. Appoint a DPO when required. This is a big one, and the sense in Israel is that there are not going to be enough DPOs to go around, and companies are going to be scrambling when August comes, and no one's going to know really what to do. Where do you find this unicorn who knows both privacy law and also understands technology and has a certain understanding of data security as well? Many courses are opening up in Israel, but it's better to think to address this issue and think about who can be appointed as a DPO earlier rather than later. Establishing oversight mechanisms for directors when required. That's gonna force Israeli companies and their directors to sort of be more serious about data security and about having kind of documentation, oversight, enforcement, et cetera. So that should definitely be something which should be addressed. And as I said before, sooner rather than later, because unlike the vast majority of the matters on the slide, the directive already applies. As of September, it's already been in effect. Ensure compliance with data security regulations. So on one hand, nothing changed with the data security regulations. They're still in there. They've been around for quite a long time. But as Yocheved noted, or maybe Netanel noted, someone noted beforehand, the new amended law specifically addresses data security regulations violations as a cause for enforcement actions. So that should in and of itself should cause Israeli companies who are subject to Israeli privacy law to take those very seriously. Data security regulation, just very, very quickly, they require kind of analysis and creation of internal documentation. And again, and also it's important to have these documents in hand if the privacy authority comes knocking on one's door and you have something to show. Also, databases that require notification, that is one of the documents that you submit is one of the documents that is required under data security regulations. Ensuring lawful cross-border data transfers. We also addressed these matters beforehand. One must ensure that compliance with Israeli privacy law, Israeli data transfer regulations that there is compliance with the same. It's a slightly different regime, and we have to ensure that again that all the data flow is done in accordance with law, that there's legal basis for such transfer. And the last point is being aware of processing data that was transferred from the European Economic Area. These obligations basically, as we said before, grants more rights to the data subjects. We might have to broaden the notice. And when dealing with data subject requests, this should be taken into account. Thank you very much. And now we will see whether we have any questions from the chat. So one question, example, if you can bring an example of an activity conducted outside of Israel, which could be deemed as subject to Israeli law. Maybe Yocheved, maybe you could chime in on that point.
Sure, I can field that one. So again, as we mentioned previously, this is very much a fact-based determination. So if you have a situation where you're servicing a client in Israel and you get some specific service request that does involve personal data, and this is a one-off situation, that's obviously a very different situation than if, for example, just pulling from an example that we mentioned earlier, if you have a digital health solution where there's an ongoing collection of personal data from patients in Israel, those obviously are very different risk profiles. And the assumption is that the more data you collect and the more sensitive that data is, such that the rights of the data subject would be impacted, the greater the likelihood is that the data protection authorities would take the view that Israeli law does apply with respect to that processing of data. Another scenario that we mentioned earlier is where database has already been collected in Israel and included in a database, and then that information from that database is exported to recipients outside of Israel. Again, if you are relying on legal basis for that transfer such that you are opting in to Israeli law, then you are going to be obviously subject to Israeli law. I see that there's a related question in the questions. Does the opt-in for exporting data require data protection authority approval, or is it a certification or notification? Can a data transfer agreement such as the SCCs be used instead? That's a great question. Generally, it does not require notification or certification to the database authorities in Israel. It is a contractual undertaking that's done in the context of a data transfer agreement. But bear in mind, because of some of the differences in Israeli law that we've discussed, generally the data transfer agreement, including the SCCs, will need to be adapted specifically for use in Israel.
I see there are also a few questions about DPOs. Great questions. Does the DPO need to be an Israeli person, or can you have a global DPO? Same question for the CISO. It's probably easier to have a global CISO because the CISO has to be kind of proficient in security and not in Israeli law. Regarding the DPO, a global DPO, well, would that global DPO have such in-depth knowledge of Israeli privacy law? That's super important. And let's put it this way: the law does not address this question. Again, we'd have to ensure that this global DPO would have an in-depth understanding of Israeli privacy law with all its specificities. So the requirement to register this anywhere, that if you now need to appoint a DPO, is there a requirement to register this anywhere? If yes, how do you register? So basically, so you have to publish his or her contact details, and also a company which has to notify the PPA of certain databases. And again, this is a very narrow subset now of all Israeli databases. One of the matters that you notify them of is the identity of the DPO.
We see another question. Given the significance of consent under Israeli law, how do you recommend that consent be obtained in the context of online transactions? Nitinella, would you like to field that one?
No problem. It's a good question. And actually, Amendment 13 does not address how consent should be obtained, as opposed to GDPR, where we have very specific requirements for consent. But like you mentioned, Yocheved, since it's very important under Israeli law, we do usually advise obtaining some kind of affirmative consent that wherever that is possible. We understand it's different than under GDPR, where we see lots of companies that are trying to avoid consent, actually using different legal bases like legitimate interest or performance of a contract, because consent can be revoked. But here, we do recommend getting specific consent. I'll note in that regard that the Privacy Authority in Israel has not addressed whether it is or is not acceptable to have a pre-clicked checkbox to qualify as a consent. We do know that the Consumer Protection Authority, which is different, has provided an opinion that a pre-checkbox indicating agreement to make some kind of purchase does not constitute valid consent. We have not seen any confirmation or reference thereto by the Privacy Authority. I'll also mention that the part that we refer to as freely given under GDPR is different under Israeli law. For example, under GDPR, employers cannot obtain consent from employees because that's considered not to be freely given. Under Israeli law, that is possible, and not only possible, sometimes it's basically required. And another difference would be like to obtain consent. I think you spoke about that we should put all the purposes in the privacy notice. Once the privacy notice is accepted, that's considered consent. So all the purposes for processing would then have consent. So again, we do recommend having some kind of affirmative consent where possible, and we do not have very clear guidelines from under the law or the PPA.
So there's another great question here. The Privacy Authority gave very low fines, and most talents left it. Do companies really need to worry? The fines are lower than lawyers' fees. I completely agree with this question, and all I can say is we will have to wait and see. The Privacy Authority keeps saying that they're going to be drafting many new people. They're going to have new personnel, new people who are going to be on top of everything. We should all be super, super worried about what's going to happen, but it's a great question. We don't really know.
The expectation, a lot of effort went into drafting and passing this amendment. This is a process that has been in play for quite a number of years. And the only reason it took so long to get this through is because of changes in the Israeli government. This is actually the third time it was introduced and third time's the charm it actually passed. But the expectation is that more substantial resources are going to be devoted to enforcement. And in addition, the EU has their eye on with respect to Israeli data protection. And there's, as Miriam mentioned, one of the reasons that this amendment was enacted currently was in order to preserve Israel's status on the EU whitelist. And we certainly can expect to see a higher degree of enforcement now that significantly larger penalties are available. Okay, so this brings us to the end of the presentation. We enjoyed spending the time together with you today, and you can feel free to contact any of us if you have any questions. This is going to be a bit of a learning curve, both with respect to companies as they try to comply, as well as with respect to the legal community, because there are quite a number of compliance issues which don't necessarily have specific directions under the law. We can expect further guidance on the part of the regulators, so you can keep in touch with us. As that guidance is released, we'll be updating regularly through our website. Feel free to join our mailing list if you'd like to receive those updates directly. And thank you for joining us.